and we're into week 8 of 2019, term 3. Thank you very much for joining me for this session. I'm sorry that I'm not available for the live session on the 14th of January. This is the replacement for that session, and I will be with you on the week 9, the 21st of January at 7 p.m. Now we're getting to that time of year where we need to talk about what happens at the end of the unit. Well, the first thing is, from my perspective, soon you'll see a big red button, the Have Your Say button, and that's important feedback opportunity for the university. It's certainly important for me. So when you do notice that big red button on the Moodle site, Have Your Say, please respond as soon as possible. In terms of the take-home paper, you know the date, and from now on through weeks 8 through 12, there's pretty intensive assessment regime. So in terms of preparation for the final assessment, you can understand that I would typically provide you with a problem to solve. And it may be, and in this occasion I will have a supplementary essay style question as well. In terms of the problem solving question, you can generally expect that I'll ask you a question from the perspective of providing advice or an opinion, if you like, to one of 3 general parties. That is, a member of the public or members of the public, a developer, for example, in relation to a project, or a member of the executive or the executive generally at various levels. Could be the council, could be state, could be federal. So generally you have those 3 parts of input. I won't be asking you, it's very rare that I would consider asking you a question to provide advice to Parliament. So you can expect it to be that the problem asks you to look at something from the perspective of one of those parties. Now, it may be state or it may be federal. Sorry, I can't restrict the answer more than that just at this stage, but I will provide you with some more hints. So if we're dealing with something at a state level, important that you understand the sorts of courts and tribunals, if relevant, that may have jurisdiction to deal with these matters. And if it's federal, likewise, which court, which tribunal may have jurisdiction. It may be that it's civil, or it may be that it's criminal. If it's criminal, it may be that the task requires you to provide advice to a defendant in relation to a criminal matter, or a prosecutor, or it may be at a step removed from that prior to the commencement of prosecution, where you're asked to provide advice, probably to a regulatory authority, as to the broad range of options that might be available to them in relation to an alleged breach of environmental law. So you need to consider each of those things from the state and the federal jurisdiction. We'll talk more about that as we proceed tonight, and I'll give you some more specific clues. In terms of the work that you're doing this week, it's very broad, and we're dealing with protection of biodiversity and climate change, a very important topic, of course. I've set for you a great deal of reading. Now, I should explain that when it comes to the reading, I understand that the text is very substantial, and I can't expect you to necessarily read every word. And I do invite you to consider the text as an important way of understanding environmental law, but primarily from the perspective of an academic observation rather than necessarily a practical application. Now, when I went through studies in the 70s and the very early 80s, I spent many years, achieved well, got a good job, but unfortunately, when I started, I had absolutely no idea as to how to actually do anything. So the emphasis that we have now, certainly with Central Queensland University, is a flipped classroom model. What it means is that in some ways, my task is to guide you through, identify the important parts that might be relevant, identify resources that are available to you, and ask you to independently and creatively, to some degree, come up with ideas as to how to solve problems looking at all of the materials that we provide. So gone are the days, unlike when I went through in the 70s and early 80s, where it was a closed book exam, handwritten, and for 3 hours we'd have to recite from memory things that were primarily in the textbook and statutes and case law. Now you have all of those things available to you, which makes it easier, but it also makes it more difficult in that you need to understand the principles and apply them in a more sophisticated manner than might be possible in a closed book exam environment. Now, last week you would have seen that I referred you to many websites and materials primarily online. I'll be doing that again this week, and you'll be wondering, well, how am I supposed to take all this in? Well, bear in mind that what we're looking to achieve here is for you to understand the basic principles, the basic structure, have an idea of the key pieces of legislation, and to some degree the key cases, and then use all of the resources that are generally available to you to investigate and then answer problems. From a practical perspective, many of the online resources are very good at providing you with guidance as to how to answer these practical problems. And it may be that when you look at the materials online, when you look at a flow chart, or you look at a document that relates to an existing case, or even reading a case, that you may then have to go back to Bates and understand the principles from an academic perspective in order to properly understand how it works in practice. So, in short, what I'm hoping to achieve in this unit is something which provides you with an ability to practically apply the principles in environmental law that we're discussing during the 12 weeks. So just by way of brief refresher, the first thing that we need to consider are the relevant courts and adjudicative bodies at a state and federal level. At a state level, for prosecutions, typically the prosecution would start in the magistrate's court, and from there it may go to the district court, or it may, on appeal, go to the Court of Appeal. I'm not overly familiar with that many cases that go to the Supreme Court from the Magistrates' Court, but there are some. But for the most part, almost all of the environmental prosecutions commence and are concluded in the Magistrates' Court. Some, the more serious matters, may commence in the Magistrates' Court, go through some form of committal process, and then be disposed of finally in the District Court. That's from a criminal law perspective. From a civil law perspective, usually the most important court that we'll be talking about during this unit is the Planning and Environment Court. But there is, of course, also the Land Court that you might consider. I'll come back to the federal shortly, but just in terms of the Planning and Environment Court, remember that that court has power to deal with planning appeals, and those appeals are on merits reviews. Now, I know that you're trying to gear up for the first assessment. Some of you may have filed your first assessment, so I'll need to be careful here. But when we talk about an appeal, bear in mind that we're talking essentially at two levels. The first is that a regulator, usually a council, makes a decision in relation to a planning appeal or planning application, and one of the parties is dissatisfied, usually the developer, for example, but it might be an objector, member of the public, and will take the matter on appeal. Well, that appeal typically would go to the Planning and Environment Court, because the P&E Court has power to deal with planning appeals. And it's a merits review. Typically, what that means is that the court steps into the shoes of the original decision maker, so to speak, in order to make the best and preferable decision. And we see merits reviews quite often in QCAT for different areas. In the Planning and Environment Court, planning appeals, merits reviews, and it's an appeal against the decision of the original assessment manager. Now, if you're dissatisfied with the decision of the Planning and Environment Court, then you may wish to exercise appeal rights from that court. And it might be an appeal instigated by an objector or a developer or a council, typically. Now, that appeal would go to the Court of Appeal. It's not automatic. You don't have an automatic right to go to the Court of Appeal. You need to seek leave to appeal. So in that regard, I'd refer you to an example case, and this is Fraser Coast Regional Council against Walter Elliott Holdings, Pty Ltd. See if you can find it. And part of the task is to convince the Court of Appeal that you should be granted leave to appeal, so that, in other words, you can get your foot in the door. When the appeal is first lodged against the decision of the assessment manager, it is essentially an appeal to the Planning and Environment Court, as we said, and your task, if you're advising the litigant, is to state the decision that's been appealed against and to specify the following orders. And it may be that the appeal is seeking an order that the appeal be allowed and the development application be refused, for example. Or it might be that you're seeking some other order in relation to it, that the approval of the development application be approved, for example, depending on whether you're acting for an objector or the developer. And if you're arguing, for example, that the proposed development should be approved or rejected, as the case may be, or refused rather, then one of the grounds that you might consider is whether the proposed development is consistent with the planning scheme, or whether it is in conflict with the planning scheme. If it's in conflict with the planning scheme, the question is, are there sufficient grounds to justify approving the application despite that conflict? And we saw that in some of the cases that we've discussed that you need to consider. Now, just bear with me a moment while I pause the video. Thank you. And the sample case, I just wanted to find the citation. Predajon against the Cairns Regional Council, 2012, QPEC 23. I mentioned that you might want to consider a couple of cases. And the reason, in terms of being sample cases or precedent cases that are relevant to this course, one of them is Predajon. And the reason for that is that if you read that case, if you understand it, you have some basic idea of what it's about. As you're reading the material or as you're looking at resources online, it gives you an opportunity to refer back to that case and better understand it. Another case is Booth and Bosworth, and that's a case that you should consider from the perspective of the federal government. And it deals with the issue of flying foxes. It relates to an application for interim injunction, and it's a case that deals with an alleged contravention under the Environment Protection Biodiversity Conservation Act, the EPBCA. So the Predajon case is kind of a useful case from which I may draw an exam question, for example, that ties together some of the aspects of development in the P&E court. Booth and Bosworth is a case that ties together some of the federal jurisdiction and deals with issues that relate to prosecutions, quasi-prosecution, contraventions, and can be looked at from the perspective of the landowner or the regulatory authority or the interested party, the member of the public. So there are a couple of sample cases to consider. Another one might be Fraser Coast Regional Council against Byrne Brothers, but don't worry about that too much. I won't be examining you on that case, as I have done in the past, on this occasion. All right, so when you see those sample cases, then pay particular interest, and I would recommend that you do some research in relation to them. We'll talk more about certainly Booth and Bosworth in the next few weeks. So let's come back to dealing with the key topic for tonight, which relates to the broader issues around the protection of biodiversity and climate change. Last week, we talked about environmental impact assessment, and that ties in to some degree with what we're dealing with here, because environmental impact, it relates to regulation by government and relates to 3 different levels. We mentioned that both at the state level and the federal level, there are discretions that are conferred upon individuals. So let's start with the Commonwealth. And the Commonwealth lawmaking includes, as part of the EPBCA, a strategic assessment discretion available to the Minister. And it's available on a subjective rather than objective test, as we talked about last week. Now, from a state perspective, in Queensland, we talk about management plans, and they're designed to protect areas, and conservation plans for wildlife and habitat. In that regard, have a look at the Nature Conservation Act 1992, and that Act, specifically section 175, subsection 2, subsection J, enables the preparation and passing of regulations to be made in relation to the management and conservation plans and to enforce compliance with them. Have a look at section 119, subsection 2, that provides that a subordinate plan is subordinate legislation for the purposes of the management and conservation of relevant areas. Okay, so coming back to the federal, the EPBCA requires the preparation of a plan of management for a park or reserve set up under the Act. And in general terms, when you look at the structure of the EPBCA, you'll see that the approach adopted in relation to the conservation of biodiversity is from 2 perspectives. On the one hand, we have the non-geographic, and then the second, we have the geographic. So what do I mean by that? Well, the non-geographic means that the EPBCA deals with the values of nature, and that nature is protected to the extent that they are or may be affected by actions for which approval of the Commonwealth is required. Have a look at the approval provisions in Chapter 2 of the Act. Contrast that with the geographical approach to the conservation of biodiversity, which deals with the protection of the value of nature in the management of areas within the Commonwealth jurisdiction. So specifically, we're talking about lands or marine environment set aside as marine reserves or park reserves, or generally Commonwealth reserves. So the EPBCA considers the conservation from the perspective of general principles and also protection of specific areas. The Act does provide for bioregional plans to be prepared. Have a look at section 176, subsection 1 of the EPBCA in that regard. And in fact, the Commonwealth is under a duty to implement a plan to the extent that the plan applies in Commonwealth areas, which is that geographical aspect that I was mentioning. Have a look at section 269, subsection 1 in that regard. So the EPBCA enables the Commonwealth area to be a conservation zone so that the biodiversity in that area may be protected while being assessed for inclusion in a Commonwealth reserve. Now, when it comes to the key areas, of course, have a look for World Heritage areas, such as the Great Barrier Marine Park, and there are specific duties under the Great Barrier Reef Marine Park Act 1975, which provides for the establishment of the Great Barrier Reef Marine Park Authority, and that authority is under a duty to prepare a zoning plan for the area. In addition to that which can be created through the executive, there is an opportunity for private project planning. We talked about that to some degree last week when I was talking about the obligations imposed on proponents to make an initial assessment as to whether an impact assessment may be relevant in a particular development or not. But from a project planning perspective, a developer will undertake planning for internal purposes, and part of the project plan may require putting in place procedures and systems to ensure compliance with any legal requirements. And this is, in practice, a very substantial area for work. And it may be, if you're looking to continue on with environmental law as your profession, then working in that space of project planning may provide a valuable way of becoming involved. Have a look at the work that's undertaken by Phil Jeston that I referred to last week in that regard. Now, from the regulatory authority, the framework needs to include a reference to environmental offsets. So it is useful to have some idea of what we mean by environmental offset legislation. And I know I'm jumping between federal and state, but I'll continue to do that, and hopefully you'll be able to catch up, or keep up rather. So let's have a look at the State Environmental Offsets Act 2014. And as you're reading that, I'd ask you to please consider the sections 3 and 7 and 8. Now I'll just share the screen. You should be able to find this. And I'm using a number of different platforms tonight. So there you'll see the Queensland legislation website, the Environmental Offsets Act 2014. I'm sure that during the time that you spent doing both introduction to law and statutory interpretation, particularly if it was with me, we would have looked at these point-in-time versions. The reason I'm specifically pointing that out now is that when you answer a problem-based question, whilst you might assume that the question relates to the period of now, 2020, it may not be. And the question might relate to something that occurred a number of years ago. So always be prepared to look at the legislation at the point in time relevant to the question. And that's not just for environmental law, that's for all pieces of legislation. And I find the Queensland legislation website far better than AustLII when considering point-in-time versions. So I'll always go to that as the preferred option in that regard. So I mentioned when you're looking at the Environmental Offsets Act, don't go into a great deal of detail, but certainly look at sections 3, 7 and 8, which deal with the purpose, what are the offset conditions, and what is a significant residual impact. Also consider the regulations and the Queensland Environmental Offsets Policy. This is the version 1.2 from June 2016, and it's regularly updated. So please look out. It may be updated. I'm sorry I didn't check on that earlier. But the Queensland Environmental Offsets Policy document is very useful because it gives you some idea of how this works in practice, because it's very difficult to understand these principles without looking at the practical application and probably then working backwards to some degree to look at the legislation. So have a look at the Queensland Environmental Offsets Policy, which has been updated to reflect the protected areas category under the Nature Conservation Act, certainly as at 2016. For general guidance in that regard, in relation to environmental offsets, I'd urge you to look at the Queensland Government website, and you'll see here that that is www.qld.gov.au/environment/pollution/management/offsets. And you'll see that there's information about environmental offsets the legislation, the framework, the regulations, and the policies. Interestingly, if you look at the right-hand side of that page, at the bottom, you'll see environmental offset policy, and always consider that when you're looking at legislation. My goodness, I showed you version 1.7, as 1.2. It's now up to 1.7, so my apologies. Please look at 1.7 and you'll see that on the right-hand side of the page. But also consider above that the financial settlement offset calculator, which is something that may be relevant from a practical perspective in determining what payments have or might be made under offset accounts in relation to environmental impacts. And you'll see that on that page, there's a link at the bottom towards the bottom to Offsets Register, where you can find out what payments have been made for such offsets in relation to environmental impacts. So very good resources, helps to put it all together in that sense. Now, I mentioned that you'll need to consider the purpose and achievement section 3 of the Act. The Environmental Offsets Act requires that Section 3 as the purpose to counterbalance the significant residual impacts of activities on prescribed environmental matters. And when we see the word prescribed, almost invariably it means go and have a look at the regulations. And Section 3 goes on to say that the main purpose is achieved by establishing a framework for environmental offsets, recognising the level of protection to prescribed environmental matters, providing for national, state and local matters of environmental significance to be prescribed environmental matters, and coordinating and implementing the framework. Section 7 talks about what is an offset condition and an environmental offset, and it provides examples. Now, the reason I'm suggesting that you need to look at this, I'm sorry I don't have the legislation on the screen. I have cancelled that page, but have a look at Section 7 because it provides for examples of environmental offsets, such as carrying out work to maintain the viability of prescribed environmental matter, or preparing a plan or conducting scientific research. And then Section 8 describes what is a significant residual impact, which is generally an adverse impact of a prescribed activity of a prescribed environmental matter that remains or will or is likely to remain despite on-site mitigation measures and is or is likely to be significant. Now, when we talk about these environmental offsets, I guess the question is, when are they applied, why, and why do we need them? So an environmental offset may be required as a condition for approval where, following consideration of avoidance and mitigation measures, the prescribed activity is likely to result in a significant residual impact on the prescribed environmental matter. And that's where the page that's on the screen now in relation to financial settlement is important. And you'll see the warning there that to perform the offset calculation, you'll need to be familiar with the new environmental offsets framework and the Queensland Environmental Offsets Policy. So I would urge you to look at that and those aspects. Just going back then, so you'll see that the key page, as we've described, is pollution management offsets. And then we have the environmental offsets policy. Don't look at version 1.2, look at version 1.7, and then of course the calculator. Now, while I'm sharing the screen, we'll move now to some aspects of the Commonwealth, keeping you on your toes. We're going between the Commonwealth and the state, then back to the Commonwealth. So from a Commonwealth perspective, a key area involving protection are marine reserves. And the Australian Marine Parks deals with the manner in which the Environment Protection Biodiversity Action, Conservation Act rather, deals with the proclamation and management of Commonwealth reserves and includes the Great Barrier Reef. So when you look at that web page, parksaustralia.gov.au/marine/parks, and you see the Australian Parks website, you'll see the specific drop-down for management, which is relevant to the discussions that we've been having. And you'll see that the management programs that I've been talking about are available to you in relation to certain aspects of the Australian marine parks. And it's a very good website, interactive as well. You'll often see the reference to science, and this subject, more than any that I can think of in law, ties together aspects of scientific and legal matters. There's also, importantly, the Great Barrier Reef, as I mentioned earlier, and Ramsar wetlands. Now, Ramsar wetlands come about as a result of the Convention on Wetlands of International Importance, which is called the Ramsar, R-A-M-S-A-R Convention, and it's an intergovernmental treaty that provides the framework for conservation and use of wetlands and their resources. And all of this is subject to conservation agreements. So when you're looking at the legislation, you'll see that there's the ability under the EPBCA for agreements to be prepared. But what does that mean in practice? Well, let's have a look at another federal government website, the Australian Government Department of Environment and Energy, and this deals specifically with conservation agreements. This is environment.gov.au/protection/environment-assessments/conservation-agreements. And you'll see there that a conservation agreement is an agreement between the Australian Government, Environment Minister, and any other person for the protection and conservation of biodiversity in an area of land or sea. And you'll see from a practical perspective there what the conservation agreement may provide for, what it can do, what it means and how it ties in with the EPBCA. You'll also see that there's reference there to the ministerial discretion in relation to action taken by a person who is thought to have contravened or may have contravened a part of provision of Part 3 of the EPBCA. So it's a very useful website, and you'll see there the agreements under the EPBCA between the Commonwealth and the various states, and the first one happens to be in relation to an area of lowland rainforest of subtropical Australia at Palmview in Queensland, and of course that agreement is made with Queensland. And the agreements can be very specific. So the third one down there, conservation agreement for protection and conservation of Bidwillie, and that is at Kawungan, which is a suburb of Hervey Bay. So conservation agreements, and this is an important aspect, are binding not only on the person who entered into the agreement, but also any successors to any interest of that person. And because this is federal, if there is a requirement to enforce something which is contained within the conservation agreement, then the application is made to the federal court, and the application is for an injunction. Have a look at section 476 of the EPBCA in relation to that. All right, well, you're doing very well. Thank you for your patience. Please keep at it. And what I'd urge you to do is, as you're listening to me in this lengthy monologue, follow along by looking at the web pages, look at the legislation, and try to tie it in together in a way that makes sense to you when it comes to being able to answer a problem. So I've been talking about the Commonwealth for a little while, probably a good time to go back to the state. So, and the state being Queensland. When it comes to state protected areas, most of the land for parks and reserves in the state of Queensland is Crown land. Now in Queensland, the important legislation initially is the Nature Conservation Act, 1992. And do have a look at the objects of that act, and you'll see that the part of the objects of the act are to achieve conservation by what they describe as an integrated and comprehensive conservation strategy that involves protection of areas representative of biological diversity, natural features and wilderness, protection of biodiversity of native wildlife and habitats, and ecologically sustainable use of protected wildlife and community education and consultation. And again, we see that term ecologically sustainable. We see that a lot in the context of development, but here we see it in the context of the Nature Conservation Act. A relatively recent innovation, which is important, is the Biosecurity Act 2014, Queensland. Let me share the screen. The Biodiversity Conservation Act commenced on the 1st of July 2016, and it provides the modern risk-based approach to biosecurity in Queensland. So what does it do? It provides measures to safeguard the economy, agriculture, tourism, the environment, and our way of life from pests, wild dogs, weeds, diseases, foot and mouth disease, contaminants, lead on grazing land. And the idea of this act is that it replaces pieces of legislation that were previously used to manage biosecurity. So it's all in that one piece of legislation in that sense. I'm a little envious of the Commonwealth system in that we, by and large, have one piece of legislation to consider. In Queensland, it would be nice if one day all of the important pieces of legislation could be put together in one piece of environment legislation, but that's a discussion for another day. Now so this is Queensland. Let's go back to the Commonwealth. And when it comes to the native vegetation framework, have a look at this website, environment.gov.au/lands/Australia's-native-vegetation-framework. And the native vegetation outcomes sought in the framework, which are administered by this Department of Environment and Energy, are to increase the national extent and connectivity of native vegetation. And all of this comes about, this Australia's native vegetation framework comes about as a result of COAG cooperation between the Commonwealth and the states. And the COAG Standing Council on Environment and Water formally oversees the implementation of the framework. Now, you might recall a case, I think in Spencer in the notes, in the notes and also in our text, called Spencer against the Commonwealth. This was a case 2008 FCA, Federal Court of Australia, 1256. And in that case, the plaintiff argued that the prohibition imposed from clearing his land without consent deprived him of an ability to reasonably use the land. That old conundrum as to how do we protect the environment but still honour the basic right of people to do with on their land as they see fit. So the plaintiff argued that as a state could enact vegetation legislation because of Commonwealth financial assistance provided to do so, the deprivation in Spencer's case was in fact an acquisition of rights without the payment of just compensation. And eventually it went to the full court of the federal court and it was dismissed, but it was a very novel argument that Spencer ran and he almost got there. Now in Queensland, we have the Vegetation Management website. So this is www.qld.gov.au/environment/land/management/vegetation. Now the framework administered by the Department of the Environment, in Queensland, the framework is administered through the department, which provides for information about the vegetation clearing requirements, vegetation maps, and other information that is interactive and very useful. The Queensland Government website provides information about proposed clearing activities and whether the activity is exempt or might be undertaken in accordance with self-assessable code requirements or requires a permit. Now, I'm going to refer you to a case in relation to all of this, and we'll use Jade this time as the platform. So this is the decision of Baker against the Chief Executive, Department of Natural Resources and Mines, 2019 QCA 128. It is, amongst other things, a statutory interpretation case, and it's a case that deals with whether the appellant had contravened provisions of the now repealed Sustainable Planning Act 2009 in relation to clearing clearing undertaken on the property. Now, in this case, in Baker's case, the appellant was convicted of a vegetation clearing offence under the Vegetation Management Act of 1999. And the question is whether the appellant sought to review those decisions in QCAT. The question is whether the President erred in finding that the decision can reasonably find that a decision of the Act can reasonably believe that a person had committed a vegetation clearing offence. The other thing where it's relevant is that it talks about the Vegetation Management Act, which provides for separate and distinct circumstances in which the decision maker may make a property map of assessable vegetation. Let's go back to a more broad discussion, and we'll now go to international materials. In the context of native wildlife, the Commonwealth responsibilities go all the way back to the 1973 Convention on International Trade in Endangered Species of Wild Fauna and Flora. So this CITES, C-I-T-E-S. And on the website, cites.org/ENG/DISC/text, you'll see the convention and the articles that go with it. And essentially, a person may not take action that will or is likely to have a significant impact on listed threatened species or endangered community without approval. Have a look at the EPBCA section 194Q. Now the penalties range from, wait for this, $550,000 for individuals up to 5.5 million in the case of corporations. and courts do impose substantial fines for breach. An example of that is the Minister for the Environment and Heritage against Lamentina, Lamattina, 2009 FCA 753, and in that case the respondent was ordered to pay $220,000 for clearing native vegetation, which was an action likely to have a significant impact on an endangered cockatoo. In another case, Minister for Sustainability, Environment, Water, Pollution and Communities against De Bono, 2012 FCA 643. De Bono is D-E-B-O-N-O. The respondent was ordered to pay a penalty of $150,000 for clearing, ploughing and rock removal that had a significant impact on a threatened ecological community. And the respondent was also required to enter into a 5-year management plan. From a Queensland perspective, when it comes to administering and protecting wildlife, once again, we go back to the Nature Conservation Act. Once again, I'll share the screen. And on the screen now, you should see extracts from the Queensland Government Department of Environment and Science, which is responsible for administering the Nature Conservation Act. And it deals with issues to do with protection of wildlife through licensing and permits. And in consideration of that, there is a requirement to protect wildlife, protect ecosystems, and the department implements policies in relation to threatened species. It also deals with issues of pollution control, as you'll see there. Now, that website, environment.des.qld.gov.au. So when we talk about these licenses and permits, you'll see that I've expanded on the screen some information about that in relation to contaminated lands, plants and animals, etc. And it just fleshes out what's in the legislation to provide a more practical aspect to this. One of the things that we see quite regularly is a reference to environmental harm. Now in Queensland, where we're trying to determine whether something is or is not environmental harm, or whether it is or is not serious environmental harm, you might recall that we refer to the Environmental Protection Act 1994. Have a look at section 17, which provides the definition of serious environmental harm. We talked about it earlier in this unit, but it's essentially we're looking at that which is irreversible or of high impact or widespread, or cause to an area of high conservation value or special significance, or something that causes actual or potential loss of damage beyond a threshold amount, or results in costs of more than the threshold amount in taking appropriate action to prevent, minimise or rehabilitate. And you might recall that that threshold amount was $50,000, or as prescribed by regulation, whatever is the greater amount. Now, some examples of where this has actually been used. Have a look at two cases. The first, and these are both from Ostley, is Bergin, B-E-R-G-I-N, against Link Energy Limited, 2016 QMC 4. This is a case that deals with the issue of jurisdiction and then the issue of penalty. Two QCs involved in this case, Ralph Devlin and Bob Bain, for the prosecution and the defence, respectively. So what had happened is that the presiding magistrate was to determine whether there was sufficient evidence to warrant the defendant being committed to trial in the district court. And that was in relation to a charge brought against him pursuant to section 17 of the Environment Protection Act 1994. In that case, the magistrate did find that the widespread nature of the alleged harm to the environment was sufficient to satisfy the threshold test, and accordingly the defendant was committed. Another case relevant to this issue was the issue of, or the case of Crowther against the state of Queensland. This is a Planning and Environment Court case, and this is 2002 QPEC 79, where the applicant sought to restrain an offence alleged to have been committed against the EPA and did so by bringing an application to the P&E Court pursuant to section 505 of the legislation. And Errol Mulzone, Judge Mulzone's brother, was involved in this case. So this is dealing with, so have a look at section 505 of the EPA, because it does deal with that issue of restraint of contraventions, which may be useful for your practical application of what we're discussing. Now, in this case, I'd recommend that you get a feel for the decision, but where I think it's particularly important are paragraphs, firstly 28. And if we go to paragraph 28, you'll see that Judge Robin QC, who has now retired, no, not 28, sorry. Okay, my apologies. I'm looking for the exact paragraph that I'm after. What I'll do is I'll read it and hopefully it will be readily found. So in that case, Judge Robin talked about the environment in fairly broad terms and said in section 8 that the absence of an unpleasant odour could be described as a quality of the place and hence the environment, that it's conducive to public amenity and therefore the environmental value for the purposes of section 9. And there's reference to a decision of Don Brass Foundry against Stead. And my apologies, I just can't find it at the moment. So what I might have to do is, here it is. There it is, paragraph 28. It is there, sorry. So have a look at paragraph 28, and it talks about this case of Don Brass Foundry. Then, I won't read it in full, but go to paragraph 38, which relates to the general environmental duty not shown to be complied with. And you'll see how Judge Robin works through the legislation and deals with section 438. Then relevant is section 40, which deals with the availability of injunctive relief, the fact that the Act binds the Crown. And the following paragraph, 41, which deals with the onus of proof. And notation that as far as the onus of proof is concerned, the Environment Protection Act is not helpful in relation to its repeated reference to convictions being possible if the court is satisfied. So it doesn't actually, and again, that's a good example of where the drafters of the legislation have written in the passive voice rather than the preferred active voice that would have made things much easier. So have a look at paragraph 41, and then finally look at paragraph 52, which will hopefully round out what you need to learn from Crowther's case. So that's Crowther against the State of Queensland, 2002 QPEC 79. Other than that, the only other website that I wanted to bring to your attention is that part of the Department of Environment and Science that deals with wildlife and ecosystems. I'll stop the share now. Well, thank you very much. That brings us to the end of what I want to talk about this evening. You've been very patient. Thank you very much for doing so. If you have any questions arising from what we've discussed this week or generally, please ask through Q&A, and I look forward to having further discussions with you in week 9 for our live session. All the best We'll see you then. Bye.